Good afternoon, and welcome to this edition of Disability Chat. Each month, HDSA and our resident disability expert, Allison Bartlett, will tackle some of the most vexing issues surrounding Social Security disability and HD. At the end of each session, Allison will take questions from the audience. Questions will be answered after the presentation, but you can send a question at any time during Allison's presentation. Just click on the chat function in the toolbar, type your question, and hit send. Your questions can't be seen by anybody else but HDSA. This presentation will be available in about a week on HDSA's YouTube channel or by going to hdsA.org/disability-chat. Today's chat will focus on debunking disability myths, an in-depth look at common Social Security disability myths at every stage of the disability process. On May 21, Allison will discuss disability red flags, what you need to know about the 6 common red flags in a disability claim and how to mediate or avoid them. And in July, we'll chat about completing disability forms, an overview of what Social Security disability forms you may receive during your disability application process and how to complete them. Allison Bartlett is HDSA's Manager of Disability Programs and is a disability attorney who specializes in representing clients with rare chronic conditions like Huntington's disease to navigate them through the complex disability system. Allison holds a JD from the University of Cincinnati College of Law and a BA in International Affairs from James Madison University. She's a member of the Virginia Bar. And now I'll turn our chat over to Allison.
Good afternoon, and thank you everyone for joining me today for this edition of Disability Chat. As Deb said, today we'll be talking about debunking disability myths. So there are a number of disability myths that happens at all stages of the disability process. And today I'm going to talk to you about myths that happen before applying for disability, while your application is pending, what to do when appealing a decision, and the myths that happen after getting an approval. So why is it important to be aware of these disability myths? There are disability myths that are associated with every stage of the process, and they are dangerous and often have a number of unintended consequences. So the disability myths before applying, why these myths hurt you. They impact when you submit a disability application and could cause harmful delay, because if you wait to apply too long, you may not be able to apply at all. They impact what disability program you apply for. They impact the quality of your application, they impact the confidence about the process, and they impact your decision to apply at all. The first myth, I will automatically be approved for disability because I have Huntington's disease. This myth is false. There is no such thing as an automatic approval for any diagnosis, including Huntington's disease. You have to prove your case. The statement, I have Huntington's disease, is not enough for Social Security. You have to prove your case through medical evidence. All disability applications require medical evidence. If you do not have medical evidence, your claim will be denied. Your medical evidence needs to show that you have symptoms and limitations as a result of your HD that prevents you from working. The Social Security disability process has to be followed to the letter of the law, and I mean actual law. The Social Security process is defined by the Federal Code of Regulations, which is the law that governs federal agencies. And this is why it's so important to follow everything Social Security tells you to do exactly as they tell you to do it. Myth, I can get Social Security disability if I have not worked. This myth is false. You cannot get Social Security disability if you have not worked or if you have not worked recently enough. Unfortunately, this disproportionately impacts certain groups of people, including people who stay home to care for children and people who are in school and have not worked. People who have not worked could possibly receive supplemental security income, but that is a different benefit with different eligibility criteria. Myth, SSDI and SSI are the same benefit. This myth is very false. There are 2 kinds of disability benefit programs, SSDI and SSI. Social Security Disability Insurance, known formally as Title II, is a different benefit from supplemental security income, known formally as Title XVI. SSDI is the better, more stable benefit program, and the national average for monthly benefit payments is $1,200 per month. SSI is the financial need-based program, and the most you will receive is $771 per month. To be eligible for SSDI, you must work and pay into Social Security. You have to earn work credits. When you pay into Social Security retirement, you're also paying into Social Security disability. To be eligible for SSI, you have to demonstrate significant financial need, which most often is close to federal poverty level. There is no resource limit for SSDI, which means you could receive a pension of $60,000 per year and still be eligible for SSDI, or have $1 million in your retirement fund. SSI, on the other hand, has very strict financial limits. Individuals must have less than $2,000 in resources, and a couple must have less than $3,000 in resources. Resources are things like your checking account, your savings account, your retirement account, personal property, if you own additional property, more than just one home, or if you own more than one car. SSDI can come with additional financial benefits to spouses and children under the age of 18. SSI does not provide any additional financial benefits. SSDI comes with Medicare. SSI, in most states, but not all, comes with Medicaid. Myth: you have to stop working before applying for disability. This myth is false. You can apply for disability as long as you are making less than $1,260 per month gross before taxes, otherwise known as substantial gainful activity. This is the 2020 amount. Substantial gainful activity limit changes every year, so you do need to pay attention to that. You have to be very vigilant and responsible if you decide to keep working while you apply for disability, because exceeding the income threshold will threaten your disability application. Social Security is very strict about their income guidelines, and you do not want to jeopardize your disability application if you're not following the rules, which again are set by the federal government. Myth: you have to wait at least 12 months after you have stopped working to submit a disability application. This myth is false, but Social Security does require that your condition will last 12 months or longer, which is the case for anyone with an HD diagnosis. You do not have to show that you have had your condition for 12 months, but that it will go into the future at least 12 months. You can submit a disability application as soon as you have stopped working or you are making less than $1,260 per month. If you have stopped working because of your HD, you should submit a disability application as soon as possible. Remember, you must be getting proper medical care and have medical evidence if you're going to be approved for disability. Myth: you have to wait until your medical condition gets really bad before applying for disability. This myth is false. You should not wait to apply for disability. You can apply as soon as your HD prevents you from working and you have medical evidence. HD is a progressive condition. The condition will continue to worsen while the disability application is pending. It is very important to note that everyone's HD symptoms manifest differently, so there is no one set of symptoms that will guarantee an approval. There is no magical combination of symptoms. And it's also important to note that Social Security does not just look at your symptoms, but how your symptoms impact you. Your symptoms may not seem severe to you, but they could have a huge impact on your life and your ability to work. For instance, you might only have mild chorea in your legs, but you experience the chorea every day, which means you trip, stumble, and fall on a regular basis, and you are now a fall risk. Being a fall risk greatly reduces the number of jobs you could actually perform. On top of your chorea, you have worsening irritability, which has led to argumentative behavior and verbal altercations with coworkers and supervisors. The inability to work with people significantly reduces the number of available jobs that you could perform. These two symptoms have eliminated most of the jobs in the regional or national economy, which is how Social Security determines if you are disabled. Do not undermine your symptoms or how they impact you. You don't know how much they could show your inability to work. And waiting to apply for disability could mean you lose eligibility for benefits because your work credits expire. Work credits If you have questions about work credits or would like more information, please review my disability chat, work credits, and how to qualify for disability at hdsa.org. It is not possible to apply for Social Security disability too soon. This myth is false. Individuals with HD are in a unique position because this is one of the few diagnoses where you can apply for disability too soon. A positive HD gene test without symptoms or limitations is not enough to be found disabled. If you apply for disability without symptoms of HD, you will be denied. It is important to speak with your doctor about your symptoms and your ability to work. That being said, your doctor saying that you are disabled does not mean that you'll be found disabled by Social Security. Doctors often are not aware of Social Security's regulations, so your doctor's definition of disability is not Social Security's definition of disability. And if you apply for disability too soon and stop working, you also risk losing your disability benefits permanently because you have stopped earning work credits. Again, it's very important to continue paying into Social Security up until the point you can no longer work to make sure you get the benefits you're eligible for. You have a severe disability, so you will not need help getting benefits. This myth is false. HD is a severely disabling condition, but you still have to follow all of the required steps for the Social Security disability process. As I mentioned on the previous slide, your doctor saying that you are disabled does not mean that you will be found disabled by Social Security. The fact that you are disabled does not mean your application will be approved right away. You are still required to submit all of the necessary information, medical evidence, and paperwork to Social Security, and I strongly recommend getting help doing this. The Social Security disability application process is time-consuming, complicated, and difficult. When I say the disability process is difficult and complicated, I mean it is difficult and complicated for everyone. I have had fellow attorneys who specialize in other areas of law tell me how confusing and complicated the disability application process can be. The Social Security disability application doesn't always seem like a fair process because Social Security doesn't always tell you the rules up front or tell you the rules in a way that are easily understood, which is why it can be very beneficial to get assistance. You could leave out important information or answer a question incorrectly on the application. And unfortunately, this is not like the SAT where they always told us to guess because it wouldn't hurt our score. If you get a question wrong in a disability application, you could be penalized for it. And if you have stopped working due to your HD symptoms, I strongly encourage you to get assistance with your disability application. Assistance can come from friends, family, social workers, doctors, and lawyers. Also, getting help means you could get another perspective from an outsider who may have noticed things about your condition and limitations that you have not noticed because you live with it every day. And that information could make your application stronger. Myth: all claims get denied the first time you apply. This myth is false. The approval rate for the initial application is 32%. But what's important to remember is not all applications are created equal. A lot of individuals are actually denied for technical non-medical reasons, and those are things like not having enough work credits or people are working and earning too much money. It's important to recognize this because 47% of SSDI applicants are denied for technical reasons. That means almost half of all applications do not make it to the medical determination stage, meaning Social Security doesn't even look at their medical condition and how their medical condition impacts the person. So if you make it past this technical stage, the approval rate for medical eligibility is 49%. That's almost half. That's much higher than the 32%. You also have to remember this includes conditions that are harder to prove, like chronic pain, spinal conditions, arthritis, heart conditions, etc. So what I know I just gave a lot of facts and figures, but the point is the chances of an approval are higher than you might realize, are higher than what people might say. There are a lot of factors you have to consider in a disability claim, like work credits, if you're getting proper medical care, and if you have medical evidence, if you submitted a complete application. If you do not finish the application correctly, you will get denied if you complied with Social Security rules and regulations. Also, assuming you will get denied could ensure that you do get denied because you may not treat the application the same way. If you set yourself up for failure, you might bring it into existence. If you treat the application with respect, consideration, you give it the time it deserves, and you give it your best chance, and you think whatever happens, happens, but I know I've done my best, you're giving yourself more confidence and giving yourself a better chance of an approval because then you know you've done everything you can. If you assume you're going to get denied the first time, you might not do everything you need to do. Disability myths while the application is under review. Why these myths hurt you. They impact how you communicate with Social Security. They impact the evidence that you provide to Social Security. They impact your knowledge of your case, and they impact your cooperation with Social Security. Myth. Social Security will reach out to you and provide updates about your case status. This myth is false. Social Security will only contact you if they need information from you. They do not have the time or manpower to provide updates. You can access your case status online, but the information is very limited, including the things that I've listed below. So your reentry number for an online benefit application or online appeal that has not yet been submitted, the date Social Security received your application or appeal, your scheduled hearing date and time, your current claim or appeal location, including the address of the office processing your application, and if a decision has been made. So you can only find out those 5 pieces of information online. If you want more detailed information about your case, you have to call and follow up regularly. I recommend every 2 to 4 weeks to ensure accurate case status and information. And by that, I mean confirming Social Security has received your medical records or other forms that you may have submitted. And it's really important to call if you have questions about how to complete a form or if you need an extension to complete a form. All Social Security forms come with deadlines, usually 10 business days from the date of the letter. If you only have 2 days to complete the form by the time it gets to you, call Social Security and ask for an extension. They're usually very good about giving extensions, especially if you explain the circumstances, and there's always no harm in calling and asking. Most people don't know you can ask for an extension, which is why they don't do it, but Social Security is very liberal with that policy. Myth. Social Security will not need any additional information after you complete the application. This myth is false. Social Security could send a number of different forms to you that need to be completed and returned in a timely fashion after you submit your application. These forms include things like the work activity report, the adult function report, or the work history report. Social Security sends out these forms to get detailed information about your symptoms and limitations and how they impact your ability to work, so it is essential that you thoroughly complete these forms. It is perfectly fine to get assistance completing the forms. Someone else can complete it for you, like you don't have to be the one physically filling out the form if you can't. And it's okay just to work with someone to get the forms completed. And it's really good to put that you got help completing the form when you return it to Social Security so they have that information. Completing these forms could be the difference between an approval and a denial. The chances of your disability application getting denied dramatically increases if you do not complete and return all of the forms Social Security sends you. Social Security sends these forms for a reason. They need the information to make a thorough and accurate decision. Myth. Social Security will collect all of your medical records. This is not so much a myth, but more of a misunderstanding. Social Security is legally required to request records from the doctors you list in your application, but that does not mean they will actually receive all of your records. You do have to make sure Social Security requests the records from the right places. You have to list all of your doctors, and when I say all, I mean all, not just your neurologist, and you have to provide the correct contact information for all of your doctors. If you don't know your doctor's contact information, call them and ask them before you complete the application. Get a business card, check the location online. There's many ways to confirm you have your doctor's correct information. It's also important to note that requesting records is not the same thing as receiving records. Medical record departments can lose their requests. The requests may not get sent to the right place, and medical record departments may take too long to get the records to Social Security. And Social Security can only follow up on records a limited number of times. If they do not get the records, they have to make a decision in your case anyway. I have known a number of people who were denied because Social Security did not get their records for whatever reason. So you have to make sure you list all of your doctors, all of their contact information, and you have to be an active participant in this process. You can and should call Disability Determination Services, or DDS, to ask about your medical record status and if there's anything you can do to help them get the records. The more you know about what's actually going on in your case, the better able you will be able to assist Social Security if they need it, and the better the chances are of getting an approval. For some things, they happen sometimes. Sometimes stuff gets misplaced. Sometimes medical record departments take a long time. If you know that information, you could help Social Security out, which ultimately means you get approved in the end. And it's always better to be proactive than get denied. Myth. Getting asked to attend a Social Security doctor's appointment or consultative exam means your case is going to get denied. This myth is false and very damaging to disability claims. Going to a consultative exam can help you get approved for disability. Social Security will request a consultative exam for a variety of reasons. If they feel there is not enough medical evidence in your case, if you have not had a doctor's appointment in the last 3 months, or if they want specific testing done, like neurocognitive testing or other mental testing. HD is a rare disease, so Social Security will be extra careful to make sure they understand the symptoms and limitations. In my experience as a disability attorney, 85% of my HD clients were sent to consultative exams, which was a much higher rate than my other clients with other diagnoses. And I will say most of my clients who were sent to consultative exams were ultimately approved for Social Security disability. So really, these are a good thing. Social Security sends you to these exams just because they want more information. Myth, you do not need to go to the Social Security doctor's appointment. This myth is false and is very damaging to disability claims. You will get denied if you do not attend the Social Security doctor's appointment. End of story. No negotiation. If you get asked to go to a consultative exam and you don't go, you will get denied. Social Security requested the appointment because they do not feel they have enough medical evidence to make a decision in your case. The Social Security's doctor appointment is free to you, but the cost is paid for the appointment with American tax dollars, so Social Security does not take these appointments lightly. If Social Security requests an appointment, you are allowed to have the appointment with your own doctor. You're allowed to ask. Social Security cannot always provide that accommodation because of time restrictions or payment policies, so your doctor might not take their method of payment, but it's always worth asking. And it's something most Americans don't know, but if you get asked to go to a consultative exam, you can always call Social Security, and you should do it immediately and see if you can get the appointment scheduled with your own doctor. You can also see about having the same testing done with your physician, then have the records sent to Social Security. Both of those are good alternate options that you can ask Social Security about. Disability myths, appealing a decision. Why these myths hurt you. They impact your opinion about appealing a decision, whether to do it or not. They impact your chance of being approved for disability, and they impact your benefit amount. Myth, you have already been denied once, so your claim will be denied again. This myth is also false and is also very damaging to a disability claim. In some cases, if you do not appeal the decision, you will lose your disability benefits permanently because your DLI will expire. And I don't want anybody to be in that position. And it's really important to note that getting denied Social Security disability does not mean that you are not disabled, that you have a bad case, or that you will not ultimately get approved. Denials happen for a wide variety of reasons. What matters most is that you are unable to work due to the symptoms and limitations from your HD, and you need disability benefits. It is okay if you get denied twice before getting approved at a disability hearing. Disability denials do not impact your claim as it moves through the process. Each review is a new review. What hurts your claim most is not appealing a denial at all. And I know that this can be a very overwhelming process, and the more you get denied, the more upset and debilitating it can be, but it is worth moving through the process. So I don't have the exact statistics, which is why they're not on the slide, but it's something crazy, like people who get denied twice, so they get denied at the initial application and reconsideration, like 50% of them don't appeal the decision to a hearing. If you don't get approved at the initial application stage, the best place to get an approval is actually a hearing. So it is worth continuing moving through the process because, again, getting a denial is not a reflection on you, your level of disability, or the claim itself. I say a lot of times it's a reflection of Social Security and how they don't always understand rare conditions, especially conditions like Huntington's disease. Myth: you should not appeal a decision. You should start over and submit a new application. This is a more complex issue because of the denial reason, but in general, I say it's always better to appeal the decision. If you receive a medical denial, then it is always best to appeal the decision. Otherwise, you risk losing your back pay or your disability benefits altogether. If you are denied because you are making too much money, you need to cut back your hours, then apply again. So if you're making too much money, that's an instance where you just want to submit a new application. If you are denied because you do not have enough work credits, then technically there is nothing to appeal. The only exception is if you worked but have not yet filed taxes for a year, so Social Security may not have your work earnings yet. You would want to appeal that and then request the processing of your lag earnings. Another thing, if you don't have enough work credits, it's possible that you can go back to work and re-earn your work credits. So if that's the case, then you wouldn't appeal the decision. You'd go back to work a little bit, and then apply again. But those are pretty much the only two exceptions. In most cases, it's always better to appeal the decision than to start over. Another exception is if you're not symptomatic yet, then it might be better to also go back to work and wait until your disease is impacting you more. Myth: you do not need to hire an attorney for a disability hearing. I wouldn't say this myth is false, but I would say it is inaccurate. And to give yourself the best chance of getting an approval, hiring an attorney definitely helps. An approval rating at hearing with an attorney is 60%, but approval rating without an attorney is 46%. You want to give yourself the best chance possible to get your disability benefits. Hiring an attorney will provide hearing expertise. They'll help like how to prepare for the hearing, what information is necessary, and how to interact with the judge. Attorneys can also help expedite the case, which means your hearing could happen faster. It can take 18 to 24 months to get a hearing scheduled. So if you can have your hearing faster than that, that's always a best case scenario. Disability myths after approval. Why these myths hurt you? Because they impact how you prepare for the future, they impact how you spend your disability benefits, and they impact your health insurance benefits and coverage. Myth: you have to wait 5 months for your first disability check when you are approved. This myth is false, but it's based on an actual Social Security rule. There is a 5-month waiting period, but for most people, that time period has already passed once their disability application is approved. There is not an additional waiting period once you are approved for disability. Example, let's say your disability starts in January 2019. You submit your disability application in April 2019. and your disability is approved in July 2019. Your benefits always start the next month, so your benefits will start in August. 7 months have passed since your disability started and the application was approved. So between January and July, that was 7 months. The 5-month waiting period is actually included in that 7 months. The 5-month waiting period starts when you say your disability starts. So in this case, you'd actually be owed 2 months of benefits. You wouldn't have to wait for money. The government would owe you extra money. The only time the 5-month waiting period really becomes an issue for families is if someone applies for disability like the day they stop working. And if you get, the average time it takes to get a disability approval is about 6 months. So again, most people won't have to wait. But let's say you apply for disability the day after you stop working, you have a slam dunk case, and it only takes you 2 months to get an approval. At that time, you would have to wait an additional 3 months for your benefits to start. But that doesn't happen for most people. Myth. You have to wait 2 years for Medicare from the date of the disability approval. This is another myth that is technically false, but is based on actual Social Security rules and regulations. You have to receive 24 qualifying disability payments before being automatically enrolled in Medicare. How much time you have to wait for Medicare depends on how long it takes you to get a disability approval. For example, an application is submitted on January 2016 and approved in August 2018. So it took this person a long time to get approved for disability. They are Medicare eligible immediately because because back pay counts towards Medicare eligibility. So Social Security looks at that whole 2.5-year time frame. And since you're owed 24 months of back benefits, your Medicare is going to start right away. But if you have an application that's submitted in January 2019 and approved in June 2019, that person won't be Medicare eligible until June 2021 because they haven't received any of their benefit payments yet. I know this topic's kind of like, this area is a little bit confusing, but essentially, when your benefit payments start and when your Medicare eligibility starts ultimately depends on the date you allege your disability started versus when your application's actually approved. In a lot of cases, even if it takes you 3 years to get approved for disability, most of the time, Social Security will approve you all the way back to the date you said your disability started. So you need to start counting from that date, not the date your application's approved, but the date Social Security finds you disabled. It is very important to make sure you have healthcare coverage while you wait for your Medicare to start. A lot of individuals do have to wait for their Medicare to kick in, and so you need to understand the rules and regulations that go around that. And unfortunately, for a lot of people, if you're currently receiving Medicaid and then you're approved for disability, being approved for disability could kick you off Medicaid if you receive more than $1,500 per month. That amount varies from state to state, and it could be less. You do need to check. If you're receiving Medicaid, then you get approved for disability and you have to wait, let's say 20 months until your Medicare starts, you're going to need to find alternate health insurance options. You could always look into COBRA, which is health insurance provided by your former employer. This is really expensive because instead of the employer paying the cost of the premium, you have to cover the full cost of the premium, and it's often more expensive. You could also look through the health insurance marketplace. If you have questions, there are some more resources on HDSA's website, but you could always reach out to the health insurance marketplace in your state. But because of the nature of HD, it is really important to have health insurance so you can continue to get medical care. Myth. If you try to work, you will lose your disability benefits. This myth is false. You can continue working after being found disabled as long as you make less than $910 per month before taxes. It is essential to monitor this amount because you do not want to risk losing your benefits. The last thing you want to have to deal with is if it takes you go through all this process, you finally get approved for disability, you still feel you can work a little bit, so you keep working, but you work too much. Social Security finds out, and not only do your benefits stop, but then you owe Social Security $10,000, $20,000, $30,000. you don't want to be in that circumstance. It is important to note that this amount changes every year, just like substantial gainful activity, as we talked about early, changes every year. This amount changes every year. So you can keep working, but you need to be really careful. Social Security has created programs to help you work and maintain your benefits. So if you are serious about continuing to work, you want to contact the Work Incentives Planning and Assistance Program. The link is here. And so once this webinar is done and it's posted online, these links will take you directly to where you need to go. Or you could also go through the Ticket to Work program. I highly recommend utilizing these two programs because Social Security will help you track your income for you so you're not responsible for doing it. And they will help you make sure you're abiding by all of the rules, regulations, and guidelines because there's a lot of them and it's a lot for one person to have to be responsible for. You earned your disability benefits. I don't want you to lose them. Myth. You do not pay taxes on Social Security benefits. This myth is not false, but it's not true for everyone. So your disability benefits can be taxed if your income exceeds certain limits. So if you're single and you make more than $25,000 per year, most people on disability, if you're a single individual and the only income you're getting is disability, most people will not have to pay taxes on it. But there are people, so the maximum Social Security disability monthly amount that you can get at this time is like $2,900 a month. Those people would have to pay taxes on their Social Security disability benefit. But if you're essentially receiving less than $2,000 in disability benefits per month and you're single, you should not have to pay taxes on it. But if you're married and you make more than $32,000 per year combined, you will have to pay taxes on it. So that probably does impact a lot of individuals. You can call Social Security and the IRS, National Treasury, and have them take taxes out of your benefits for you. You don't have to pay it at the end of the year. Having to set aside benefits to cover your taxes is not something I want anyone to have to do. That gets complicated. You might not set aside enough. It complicates things. So it's always better to have the government take the taxes out of your benefits instead of having to pay them back at the end of the year. And it's also important to note that your back pay can be taxed. So let's say you're someone who it took 3 years to get your disability benefits, and you got a large lump sum payment of $50,000 from Social Security. That money can and will also be taxed by the government. But you can reduce your tax burden because technically, so you got $50,000 in 2020, but really a lot of that money should have been paid in other years. It should have been paid in 2017, 2018, and 2019. And so if you work with an accountant, I believe there is a way to get the tax burden so it's spread out among those years instead of having to pay taxes on the $50,000, which would be a lot more in taxes. It's definitely worth talking to an accountant. It is really important if you get a lump sum back payment to make sure everything's done appropriately, because again, you don't want to get this large sum of money, you spend all of it, and then the next year Social Security needs $10,000 in taxes. You don't want to put yourself in that position. So those are all the disability myths that I have for you today. Are there any questions?
So Allison, we do have something from one of our listeners. How does someone find a good disability attorney that understands Huntington's disease and maybe has a good track record of getting approval quickly?
Okay, that was a really hard question today. Thanks, guys. Unfortunately, I don't know. I really don't know because Huntington's disease is a rare condition, there aren't very many attorneys that specialize in it because attorneys practice in a limited geographic area. And most disability attorneys just practice disability as a whole. And so I think it's difficult to find an attorney that specializes in HD. Really what you want to look for is an attorney that is willing to work with you, communicate with you, and learn about HD and maybe learn about like the Social Security process and is just more receptive to having actual conversations with you. If you have an attorney and you feel they're not listening or they're not really doing what you ask, it's okay to go find another attorney. And it's okay to ask questions and have certain demands of an attorney before you hire them, because you are hiring them to represent you, and you need to make sure that they're going to be the best attorney for you. And there are a lot of good attorneys out there. Doesn't mean they're going to be the right one for you.
Okay, we have another question. What training would you recommend for social workers who will be assisting persons with Huntington's disease with their claims?
So, well, that's also a difficult question. Well, definitely reach out to me directly, and will work with you. That was one of the things where it's supposed to be. I was going to be giving a training at Convention for Social Workers this year. We'll see how that goes. But I'm also working on resources. One of the important things is just really to understand what the Social Security listing is, which is public information. That information is on HDSA's website as well, so Social Security has a specific listing for Huntington's disease. It's 11.17. Understanding that listing and knowing what kind of medical evidence Social Security is looking for is really the first step, because that kind of dictates all the other work someone needs to do. So something that's important is knowing that a positive gene test, Huntington's disease gene test, is not enough information for Social Security. You have to show symptoms and limitations. So if your social worker knows that and they know what kind of symptoms and limitations Social Security is looking for, then that will help with the rest of the application process. There are a number of resources on HDSA's website that are a really good starting point. And as I hopefully get to be in my position longer, there'll be more resources to help with social workers and everyone else in the community.
So we do have a question from one of our listeners with regard to the listing. What's the difference between mentioning adult onset Huntington's disease and just Huntington's disease in your application?
So adult onset Huntington's disease is a mouthful, so I will not refer to Huntington's disease as that in my presentations, but I highly recommend stating adult onset Huntington's disease when you submit a Social Security disability application, because that should help your application get flagged for compassionate allowance. I don't know why, but the way Social Security has flagged Huntington's disease on the compassionate allowance list, it goes under A, not H. Again, the compassionate allowance list is public information. You can find it on Social Security's website. If you're scrolling through, Huntington's disease is listed as adult onset Huntington's disease. It's always best to use all of Social Security's keywords just to make sure it gets triggered. And you want your claim to get correctly triggered for compassionate allowance because it's supposed to expedite your claim through the system. Your claim can't get expedited through the system if it's not correctly flagged. And that's another thing that's always worthwhile to call Social Security about. Once you submit your application, especially if you've done it online, call Social Security and ask if your claim was flagged for compassionate allowance to make sure it was flagged correctly.
Okay, we have a kind of an interesting question here. If a person with HD doesn't have any worker credits, is it still worthwhile to apply? For example, what happens if their working spouse dies or they get a divorce?
Oh, guys, you're giving me all the difficult questions today. So if your spouse dies, you could actually get disabled widowed benefits, but you have to be over the age of 50. But so disabled widows benefits are one of those. It's sad because it means your loved one has to die for you to be eligible for those benefits, but it is one of the few exceptions to not having enough work credits and being able to get actual substantive benefits. If you get divorced, there's still always the SSI option, but it gets more complicated because SSI does look at financial resources like alimony. If you're divorced, but you were married for more than 10 years, you could still ultimately get part of your spouse's retirement benefits, but that doesn't help for disability benefits. Unfortunately, there are not enough protections regarding disability benefits because when all of these programs were put in place, they're put in place under the assumption that the nuclear family would stay intact and divorce wasn't going to happen. or your spouse didn't die until you were over 50. I don't really understand the reasoning behind these things. But unfortunately, at this time, if you get divorced or the person who is earning benefits dies and you're not over the age of 50, the only real option is SSI benefits, which is a very hard criteria to meet for a lot of people.
Thank you. With regard to the denial process, earlier you had said that you can be denied in the technical stage. So if you're denied in the technical stage, is it better for you to appeal, or is it better to reapply?
If it's a technical denial, in most cases, it's going to be better to just reapply. And the only so if you don't have enough work credits, but you decide you want to go back to work to earn work credits, and you eventually earn enough work credit, if you're making too much money, you can't really appeal that. You're making too much money. The only way is you just have to stop making too much money. But you can't appeal the fact that you were making too much money because you were just making too much money. So you would just need to stop working or cut back your hours and then apply again. The only exception to that kind of technical denial is if Social Security denies you because they say you don't have enough work credits. Let's use this here for example. Let's say Social Security, like you submitted an application in January and you've been denied in 2020 because you don't have enough work credits, but you haven't filed your 2019 taxes yet and you worked in all of 2019, so you do actually have enough work credits, it's just not showing up in the system. That's when you would want to apply or appeal that technical denial. But in most cases, if you have a technical denial, you just want to look at what the technical denial is, kind of reevaluate, and then reapply when you're ready.
Thank you. That clarifies it greatly. So we have another question from one of our listeners who works in patient advocacy, and they've been hearing from patients who have been on SSDI and SSI who've received notices that they're no longer disabled and they no longer will receive benefits. You shed any light on why Social Security is doing this?
So Social Security reevaluates every disability claim across the country. It's part of their federal rules. It's their law. It's written. So every case, every disability, regardless of your condition, does get reevaluated and reviewed. Social Security, when you are found disabled, it actually says in your award letter when your case is going to be reviewed. Most people don't get that far into the letter. It's on page like 4 or 5. But Social Security tells you up front that your case is going to get reviewed, and they're going to tell you, and they tell you when they're going to do it. So Social Security sets this review process based on the severity of your condition. Conditions that are likely to improve, your case is going to get reviewed in like 18 months or 2 years. Cases that Social Security is not sure about, then you're put on a 3-year review track. Cases that are considered a permanent disability, like HD should be in every case, should get reviewed only every 5 to 7 years. But because Social Security in a lot of circumstances doesn't understand HD enough, they don't flag them correctly. They never put them in the likely to improve category. They put them in the might improve category, so the every 3-year review process, but that does change the information Social Security is looking for. So this is one of those instances where someone might have been sent a form from Social Security that they didn't take seriously or fill out correctly. Because Social Security never just up and denies, like stops your benefits unless you're working too much, which I talked about in my presentation. But if they've sent out information for your case to be reviewed, they will send you a form. Most people, it's just a quick 2-page form that'll ask you questions. Are you still disabled? Are you still getting medical care? What's the name of your doctor? What's their contact information? Has your doctor said if you can work or not? You fill that out, send it back. Sometimes you get sent a much longer form that's like 15 pages long that has more information. You fill that out, you send that back. If you've done both of those things and then you get a letter saying that you're no longer disabled, it's because Social Security went out and got your medical records and they think your condition has improved. So without looking at some individual cases, I can't say why Social Security stopped someone's benefits. If they stopped going to the doctor, that's why Social Security would stop someone's benefits. There are a multitude of reasons, but if it's someone who has HD, like if it's legitimately an HD patient and they've been continuing to get care, even if it's only going to the doctor once a year, and they can show they've been going to the doctor, their case has likely progressed, so their benefits shouldn't be stopped. But it's important to recognize that your case is going to get reviewed when you're found disabled. It happens to everyone. So you need to continue making sure that you're prepared and you have these things in place.
So is the review process longer if you are disabled under compassionate allowance, or is it the same process?
So in most cases, like if you have HD and your case was correctly approved the first time and you're put in that 5 to 7 year category, you're literally sent a 2-page front and back form that maybe has 15 questions on it that are just the questions: are you still disabled? Are you still disabled from HD? What's the name of your doctor? When did you last see your doctor? Did your doctor say you're still disabled? And usually that's enough.
So
And you
does it
send that
matter?
form back.
Right. So does it matter if you are deemed disabled under compassionate allowance or under Huntington's disease, or is there a difference?
So the compassionate allowance part of it, I don't think matters as much, because compassionate allowance covers a lot of different conditions, and there are some compassionate allowance conditions that are fatal within like a 1 or 2 year time frame. So those cases likely won't make it to the review point. It's the HD itself, because that's considered a permanent condition. It's really compassionate allowance has to deal with like the timeliness of how serious your condition is, and the review process is based on the permanency of your condition.
Okay, thank you. Thank you for clearing that up. All right, well, we are just about at time. I want to thank everybody. I want to thank Allison for taking all these questions. And I'll turn it back to Allison to close this out.
Well, thank you everyone today for listening. I hope this was helpful. If you have additional questions or concerns, you're always welcome to contact me directly and utilize the resources we have on HDSA's website. Thank you very much. Everyone stay safe, and I hope you have a wonderful afternoon.